Test idea. Test idea. City, do we have one? No? Okay.
Good morning, everyone. Bienvenue à tous à la première réunion du comité de vérification de la conformité pour les élections municipales. Welcome to the first meeting of the Election Compliance Audit Committee. Before we get to the election of the chair, are there any declarations of interest? Est-ce qu'il y a des déclarations d'intérêt? Seeing none, we'll go on to the first item on the agenda, which is the election of chair, l'élection d'un président et un vice-président. I will now open the floor for nominations for the position of the chair. Member Vizina.
Yes, I would like to move that Jean-Pierre Kingsley be elected as chair.
And Member Kingsley, do you accept the nomination?
I do.
Okay, are there any other nominations for the position of chair? Est-ce qu'il y a d'autres nominations pour le poste de président? I don't see any, so I will close the nomination process, and I will declare that Member Jean-Pierre Kingsley is now the chair. Jean-Pierre is le président du comité. So, JP, if you would like to move over to my left-hand side.
Well, first and foremost, thank you very much for this show of confidence. I'm more used to chairing executive meetings as opposed to quasi-legal ones, so I will rely on the members and legal counsel to ensure that I do follow the procedures as required for a quasi-judicial body. But one of the ways I intend to do that is to take my time in chairing the meeting. And with the members' approval, I'll proceed with the second item, which is the election of the vice chair. Are there nominations for vice chair? Yes, please.
Yes, I'd like to nominate Doug Wallace for the position of vice chair.
Do we need a seconder? No? Okay, so the motion is moved. If elected, will you accept the position?
I would be honored to accept.
Thank you. Are there other nominations? No other nomination has come forward. I'm pleased to recognize that you're now the vice chair of the committee. Thank you. And the second item under my chairmanship is the Election Compliance Audit Committee, the terms of reference. This was sent to us for information more than anything else. But if there are questions that members would like to ask for clarification, for a better understanding, this is the right time to do it, insofar as I'm concerned, if this is okay from a procedural point of view. Are there questions that people would like? Yes, Lloyd, please.
Mr. Chair, in reading through the document, the terms of reference, I noticed that they make reference to the subject of dealing with an audit and moving forward of a compliance audit. And the wording that's used is that the committee's role is reviewing the auditor's report, and if the report finds a contravention did occur, deciding whether legal proceedings should be commenced against the candidate. And my recollection of the discussion we had in our orientation was that if there is a contravention, the committee may do two things. One is pass it forward through the courts, or if there is no contravention, simply refer or indicate there's not a contravention and refer it to city council for their determination of whether costs should be recovered or not. So I wonder if I could ask, I guess, firstly, staff, and our legal counsel as to which one we work under.
So, Chair, the language in the terms of reference reflects the language in the Act, and the Act is Section 81.4, and again, there's a difference between shall and may, and when the legislation says may, it implies some discretion, and so the notion of providing the committee with the discretion may is to decide is consistent with the Act, and that is how terms of reference are developed. That said, your legal counsel would also provide you advice on a case-by-case basis.
Please.
Staff is absolutely correct. 81 sub 14 of the Act provides that the committee may do either A or B, which is intrinsically dependent on whether or not the audit report shows any apparent contraventions. I've taken a look at the case law again. I just want to be absolutely clear on this issue. There are two streams of case law dealing with the discretion to be exercised by a committee under 81 sub 14. The more recent cases coming from the Ontario Court of Justice, which is really the prosecution's branch and the decision-making branch, if you will, when there actually is a prosecution brought forward, has held fairly conclusively that any discretion would lie with the prosecutor and not with the committee. Where then we get into the issue of whether or not it's a de minimis type of breach, where it's something that's trifling and it's not really impacting the electoral process. However, there are two cases, which is Jackson versus the City of Vaughan, first at the Superior Court level with Justice Lowers, and then endorsed at the Court of Appeal in 2010, where the court endorses a limited form of discretion based on administrative law principles. The general idea behind this is that there are 5 principles that you should be taking a look at or being mindful of when the committee is exercising any discretion to order a prosecution or to resolve to have a prosecution go forward. At the end of the day, what the court writes is that a decision to prosecute the slightest apparent contravention will run into problems of unreasonableness. So the decision-making paradigm, if you will, that you have to be mindful of is that you have to make a decision which is consistent and consonant with the purposes and the objectives of the Act, also taking into account purely relevant considerations which include the scale of the apparent contraventions. For example, in these particular cases, what the court finds is that if somebody forgets to inscribe, for instance, a postal code in the description of a contributor, that's really quite a trifling thing. That's not a huge mistake. I mean, it is contrary to the Act. However, it does not in and of itself run contrary to purpose and the intent of the Act is to have transparency in the financing process. If, however, you have something where somebody does not describe, 6 to 15 different contributors, then that would be a much more serious issue. You have a larger scale apparent contravention, and in that case, the committee would be well placed to report the matter back to have a prosecution go forward.
Yes, so I guess it's a question that we may want to ask at a point where we actually deal with an audit report that has a contravention. If we're not certain, we should seek your opinion.
If you're not certain, I'd be pleased to answer any questions you may have when the circumstances arise.
Thank you.
Please.
Mr. Chair, through you to our legal counsel, I understand that you're also able to provide us with the written cases that discuss these two branches, as it were, of divisions of law so that we can take a look at them in advance?
I can absolutely do that. I can assemble a brief for you and send it all to you via email if that's your preferred method of receipt of these documents. I can also note them up for you. Also, what I would suggest and what I'm offering is to provide you with a flowchart spreadsheet, if you will, which is the decision-making process, which references the applicable norms as articulated by the case law for the exercise of your discretion at both the first branch of the test, which is when you initially accept or reject an application which is made, and then secondly, what factors you should be considering when an audit report comes back and shows that there is an apparent contravention.
And just to follow up on that, I understood your opinion still stands that the cases dealing with this discretionary administrative discretion do not allow an administrative discretion on the first issue, namely upon receipt of the application, and we're judging whether to grant or refuse the application.
That's correct, subject, of course, to the same caveat that if it's just a matter of somebody not putting in the postal codes, I mean, that's something that you would have to weigh as a committee. However, the objective of the first part of the test, if you will, which is when you get the initial application, is merely to see if there are reasonable grounds to have an audit proceed. The threshold is far lower at that point, and also considering that the auditor will be taking a look at the totality of the election campaign finance reporting, it's certainly open to you to say, well, you know, you don't think that just because there's a postal code that's not there that it shouldn't proceed forward, but that may be indicative of something larger. That, of course, is something that the committee would have to consider.
Thank you, and I can foresee that we may well have occasion to call upon you after we've read and digested the cases and come to apply them in a particular case. But in the meantime, this has been very helpful. Thank you.
Thank you. Thank you. Any further point to for elaboration on the terms of reference? No? I wanted to ask one question. I think I'm entitled to ask a question as well of our legal counsel, or perhaps the deputy clerk. What does the committee get to know about applications that are turned down because they're viewed as incomplete by the clerk of the city? Do we get to know anything or nothing at all?
The committee wishes to be provided with that as information. I don't see why we couldn't provide you that with information, keeping in mind that we would be working with an applicant to assist them in ensuring that whatever administrative help we can to provide. So if, for example, someone is not clear how to fill it out, or if someone is not clear how to go to a client service center and swear before a commissioner of oaths, we would provide that. If at the end of the day, however, it is not a complete application, we're not providing judgment on the substance. But we would not, for example, take an anonymous application. If it is an anonymous request, we would not forward that to you. That's not something that would happen. If it's a matter of someone having trouble filling out the forms, we would provide them with every administrative assistance to ensure that the forms themselves are not a barrier, if that answers your question.
Yes. Thank you. Any point on this? Janice, please.
If I could just follow up on that. Then if somebody submits an application well within the time frames and you find it lacking when you review it, is there a back and forth then that would happen up until the deadline hits? If you're still sitting with an incomplete application, I assume at that point you would reject it. Okay.
And that is where my request came in, or my query came in about our getting to know that. There is nothing to prevent you from sharing that with us.
Nothing.
Okay. Do we need a motion to say that we would be interested in receiving this information? No?
I would
Staff
so
can-
move.
Staff can take that as
The committee
direction.
receive the report.
Staff can take that as direction. It will be, I will say, however, that anonymous complaints we won't be forwarding in any case.
So do we want to proceed with the motion, or are we satisfied with the fact that the staff takes this as a direction?
I'm quite satisfied with that.
So the motion is removed, okay? And we will appreciate the fact that staff takes this as direction, okay? The other question that I had concerning the terms of reference occurred to me where something becomes known to the committee as public knowledge, where it's almost prima facie evidence that something has occurred. What are the legal obligations of the committee? I mean, I know we have the provincial statute, but we also have the criminal code, where an offense has been created or seems to have been created. What do we do in those cases? Are we absolved automatically for any consideration of that? Or do we have a legal obligation in this circumstance?
It's a very interesting question.
But there will be more.
Can I ask for an adjournment? No, I'm kidding. My initial thought would be that because you don't have any inherent jurisdiction, you don't necessarily have the power to take what would be the equivalent of judicial notice of anything. But as individuals, you have your senses of observation, and you're out in the public, and you read what everybody else reads. Now, the fact that you receive something that's, or learn of something that's in the public sphere, as long as it doesn't prejudice or bias you one way or the other, which usually it wouldn't, because it's not something that predisposes you until you've made a public declaration about how you're going to deal with something. The fact that something has been reported somewhere is, in my estimation, far less than prima facie. It would be merely no more than hearsay, which you would be entitled to test when people come before you. The fact that something gets reported publicly poses rather vexing problems, whether it's reported on Facebook, Twitter, mainstream media, non-mainstream media, in the sense that there are real credibility issues. I think we've all seen cases where newspapers get sued for any measure of libel or defamation because they simply didn't get their facts right. And that is something that, as committee members, you would have to keep in mind, and whatever you do learn of is just one of those things that sits in the back of your mind, perhaps even the forefront of your mind, and you're entitled to ask questions about it. But I would certainly caution against taking what would be tantamount as judicial notice of anything which would go to the substance of any issue that you have to decide.
I think we all understood that answer, right? But if anyone does get knowledge, the committee is entitled to consider what it wants to do with this knowledge, is what I understood the answer to be, with the usual cautionary words.
I think if you have knowledge, you have to be mindful of what your mandate is under the Act. You don't have any independent or inherent power to commence anything or to commence an investigation. You're only seized of a matter once an application properly made and responsive to the requirements set out in the Act ends up coming before you, which means that you cannot properly go out and commence something because you've heard of something.
Okay.
What you can do is if somebody appears before you on an application and there's some information that's been put out publicly, you're certainly entitled to ask questions on that.
Okay. Please.
Through you, Mr. Chair, to the Deputy City Clerk. My understanding was that our whole jurisdiction of the committee is founded upon the receipt of an application. That's the beginning of our jurisdiction. Do you have any comment on acting, on the committee acting without having an application following the prescribed form before it?
That is the basis. The legislation talks about application-based receipt of complaints. So the Vice Chair has accurately reflected our understanding and what I understand your legal counsel to have also advised. You are here as a quasi-judicial body to hear complaints objectively and to go forward with a decision on whether or not to ask for an audit. That is what the legislation defines as your role, and it is relatively specific in that regard. And because so much of this compliance audit committee legislation in the sections uses the term shall with very modest mays, I'm not clear that we would see any ability for the committee to go beyond what is in the Act, which means complaint-driven.
My purport, of course, was to make sure that we understand that we do not have a legal obligation under another statute that impacts upon this statute. In other words, the criminal code, when you know something, a crime has been committed, you have obligations under the criminal code. And I wanted to make sure we were held harmless. If something credible comes to our knowledge, but it's not a complaint that has been officially filed, we do not have an obligation. That's what I wanted to make sure that I understood the answer.
That is absolutely correct. If I can draw a parallel to the courts generally, the court will not seize itself of any matter unless somebody seizes the court appropriately in accordance with the processes and so on and so forth. It's exactly the same thing here. You have no jurisdiction to do anything as a committee until such time as you get a properly framed and tabled application before you, at which point you're entitled to test if it's an elector, if it's with respect to a candidate, and so forth. If you do as individuals learn of a criminal or quasi-criminal offense having been committed, then that would be something that would be in your own personal sphere of what you wish to do, but it does not impact on what this committee is required to do, or can do for that matter.
And if I may add, Chair, if you actually look at Section 81, sub 17, even with your jurisdiction, the section does not prevent any individual from laying a charge or taking any other legal action at any time with respect to an alleged contravention of a provision of this Act, meaning that a citizen does not, an elector, an eligible elector, does not in fact have to come to this committee. They can lay charges on their own.
I'd like to temper that a little bit. There's a few decisions in the case of Odsys versus Santa, going back to the mid-2000s, going up to the Ontario Court of Appeal, where Justice Charon, as she then was, held that there is that saving provision in the statute itself, but to give the legislative purpose as a whole a meaning which is practicable in the circumstances. It has to be read to mean that if there's an elector who has reasonable grounds to believe that an election campaigning finance provision has been contravened, then they must follow the process set out in the Act, which is to make an application to you. If they do that and you choose to reject their application, they cannot then go and lay a charge independently under the saving provision under 8117. If they do not come to you first and they go directly to the courts by laying a private information, from my review of the case law, there's not been a case that's dealt with that yet. That would remain to be an open issue, and I suspect that somebody would raise the argument that because the courts have held that the Act is a complete code for prosecution and investigation in these matters, that they would probably be ousted from that particular provision as a right. But that remains to be seen.
Thank you. Any further comment from the Deputy Clerk? No? Any other comment from any member of the committee? Do I take it that we accept the...
I move that the report be received.
Motion that the report be received. Everyone in agreement? There's a vote? It's unanimous. The next item of business concerns the rules of procedure for the committee. The rules of procedure are rules that we must accept and not just receive. So we must ensure that we're satisfied with the rules and with their meaning. So my first point would be, does anyone wish to raise any point or make any comment or raise any question concerning the rules of procedure that have been prepared for us by the clerk for our consideration and acceptance? Any comment? Any question? Yes, Douglas.
My only comment is I'd like to congratulate the city clerk's branch for bringing forward the same rules with two very important modifications that they've seen fit to make from the previous rules, with which I'm entirely in accord. Thank you.
Thank you. I wish to raise a few points so that we can, at least I can understand what the rules of procedure mean. The first one concerns item 3 sub 2, where 3/4 of the membership is required to amend the procedures. And I'm wondering why 3/4? I mean, if there are 3 people, if the quorum is 3, how do you get 3/4 other than getting unanimous? So I'm a little bit confused. And is this standard? Is this different from last year or preceding committee, or is this new? Please.
3/4 is a standard that is used. If it's a quorum of 3 and you prefer to make it 2/3, that's certainly within your discretion to do. The notion is that your rules of procedure shouldn't necessarily be changed easily. That said, if there's a practice that occurs that's difficult, as there was in the previous term where the committee went in camera to essentially have a meeting that was not sanctioned by the meeting's investigator, and we've changed the rules of procedure to reflect that, as the vice chair indicated. The intent is not to, that your rules of procedure are your guidelines and should be in place as much as possible and should not be easy from a procedural perspective, a notion of fairness, everyone's guidelines, to change midstream. If you'd like to change it to 2/3 just because the numbers for quorum are 3, that's certainly, there are no issues with this. We would have trouble with it being necessarily a 50% plus 1, and at the end of the day, if you're 2 of 3, you end up with 2/3 in any case.
What if the number were 3 members? 3 members are required. So if there's 5 people in the room, 3 carries the day. If there's 4 members in the room, 3 carries the day. If there's 3 members present, 3 carries the day. It must be unanimous. So we have always got at least 60% of the membership agreeing, as opposed to a 2/3.
That would be within the committee's discretion. In general, the clerk's office would not advise less than 2/3 typically, but it is entirely within the committee's discretion.
Yes, please.
Mr. Chair, as the committee is 5 people, presumably more often than not, we will be sitting as a committee of 5. Yes, true, 3 will be a quorum, and but in that case, it would not be 3/4. The 3/4 rule, or 75%, would require 4 votes in favor of changing the procedure, and you have to note carefully that it's of members present and voting. So even if you had, well, if you have either 4 or 5 people, I think to change the process, 3/4 is still a safe rule to follow, and it may vary from 3 to 4 depending on how many people are sitting.
In effect, it means we can never be less than 4 to make a change.
If the full committee is sitting, yes, and voting.
Okay.
And
I will defer to what we have, but I wanted to make sure people understood what it is we're accepting, and that's the rule by which we'll be bound as soon as we accept these procedures right now. So we're going to be bound by it, and we'll have to respect that. So if there's no...
I agree, but I do think it's natural to have some slightly higher percentage than a mere quorum if you're going to depart from established rules.
Okay. I will accept that. The next question was item 8, sub 1, sub 2. The meeting of the committee can only take place at the request of the clerk under sub 1, or when a majority of the members, that's 3, requests it of the clerk. And is this normal that the meeting can only be convened by the clerk? Because either way, it has to go through the clerk. The committee cannot convene a meeting unless there's a meeting here and 3 members agree to convene a meeting again. So the question is this normal procedure?
Yes, and the statute is very clear that the clerk initiates proceedings based on the receipt of an application and the appropriate statutory deadlines that need to be met. That being said, should it be necessary for you to, for example, hire an auditor, there may be a desire at some point to receive an update from an auditor before a report is received, or there may be very good reasons in the moment that the committee wishes to have a meeting itself to discuss, for example, an improvement of an engagement letter for an auditor or where that goes that isn't part of the normal statutory process, and you feel is necessary that we wouldn't necessarily initiate on our own. So that provision is in there to allow for circumstances that the committee itself might wish in the circumstances of the moment to have a meeting.
Okay. Any concern about this, Douglas?
I'm not concerned, Mr. Chair, in that, yes, it can be convened by the chair, but perhaps the chair would advise us, but I would strongly suggest if the chair of a committee went to the city clerk and said, I would like you to convene a meeting so that our committee can get together to do something such as we're doing today, I'm sure that the clerk would be responsive to our request.
You're talking about the chair making the request.
Yes, I think
but
I think as a practical matter, if the chair of the committee asked the clerk and said the committee would like a meeting, would you please convene one for this purpose? Perhaps we could ask the city clerk's comment on that, but I suspect...
Please, Leslie. How do you react to that?
I think it would be rare if the committee felt it necessary to meet that the clerk would ever say no. The role of the committee, again, is very specific under the Act. And so, and much of it is, in fact, again, at the instigation of the clerk. What we did is we did, however, allow for a provision of if the committee itself and again, in our sort of scenarios, might be if an auditor were engaged. And that would be a new process for this committee. If the committee, for example, wished to set up its procedures for working with an auditor, setting up a subcommittee to oversee the engagement letter and manage that, that would be a reason to hold a meeting that's beyond the act. And so the provision is if the committee deems it, and we would presume that we would receive that through the chair, but it may also be that members of the committee believe that it would be necessary and advisable, and that's what this mechanism is intended to be.
Well, to come back to Douglas's point, will it be acceptable to the clerk if the chair transmits a request from the committee and I have had an opportunity to discuss with members? You don't need a formal motion to this effect?
No.
Okay.
If I may, Mr. Chair, I'd just like to highlight a distinction in wording in the rules themselves. The meetings referred to in subs 1 and 2 of Section 8, in my mind, would refer to the initial meeting following an application being received, where under the Act, once the application is received by the city clerk, then that gets forwarded to you in the context of a meeting to consider. Once you commence your meeting on that application, it seems to me that subs 1 and 2 have been exhausted with respect to the calling of a meeting by the clerk, and after that you're always within the same meeting. You simply don't end it, but you adjourn it to go on to the next phase of that meeting, whether it's for the audit report itself and so on and so forth, and at that point you end up being within your own processes.
Thank you. Nothing further on that point, because I have another. Okay. Section 10, sub 2. This deals with a party not showing up once proceedings are initiated. And it says the party will not be entitled to further notice of subsequent meetings. And I'm wondering, how do we square that with natural justice? I mean, just because the party missed one meeting, why is he not entitled, why is she not entitled to notices of other meetings? On the wording of it, and I just want to add that I was not involved in the drafting of these particular rules of procedure, but on my read of it, that would be entirely consistent with what we find in front of the courts generally, where you get a notice of time and place. You're supposed to show up for your hearing. If after 15 minutes after the start of your hearing you do not appear, then the courts will proceed without you. It's the same thing as the default proceedings provisions under the rules of civil procedure in Ontario, and it's also the same in Quebec, the same in federal court as well, where essentially once you are in default, you're not entitled to get notice of further proceedings because it is assumed that you have already presented to the decision-making body that you don't wish to participate or you don't care enough to participate. Either way, the requirements of natural justice are met because you provided them with an opportunity to attend and make their presentation. If they choose not to attend without valid reason, of course, then they've had that opportunity, and the committee is well placed from a legal perspective to carry on without that person. Subsequent this question then is, does the committee then have the discretion to provide further notice to the party if it wishes to do so? Or is that preempted by the fact that the statute or the procedure is written as it is?
Without having considered the rules of procedure in their whole in any great detail, my suggestion to you would be that you would have that residual discretion because you are entitled to change your practice moderately as you go forward. There may be some overarching reasons for which you would want to provide notice to somebody. For instance, somebody was involved in a car accident and they couldn't make it to the hearing and so on and so forth. But absent that, once your rules of procedure have been adopted, you would be well advised to abide by them and not provide any further notice.
Okay. Do you wish to add anything, Leslie? Please.
Provision really talks about the party not being entitled. It doesn't, in my reading of it, restrict the committee in saying asking for one more additional notice, or where it goes, what it says is the party is not entitled. At that point, we would expect that the committee would ask the advice of its legal counsel. But in terms of as it's written, it speaks to the party, not to the committee's ability, one way or the other, to ask for an additional notice in a given circumstance.
Okay. Are we okay with this? So we do have some leeway, depending upon the circumstances. If we think that something untoward happened to that person and her ability to show up at the first hearing. Yes, Lloyd.
Yes, my understanding of the rules of procedure are that we could change them at that moment to provide a subsequent hearing, or I believe we could adjourn if that was the only item to be discussed. That's a question, actually.
The rules of procedure in this regard really speak to what the party is entitled to again. So if the committee itself feels for whatever circumstance that they would like to provide the party with additional notice, then I don't see anything in these rules that prohibits them from doing that, in particular after you've received advice from your legal counsel. So from a meeting perspective, it wouldn't stop you from doing that. What it does say is the party is not entitled.
Just as a very practical matter, I know lawyers aren't supposed to be practical, but as a practical matter, I can't imagine us getting into any legal problem because we went beyond the strict requirements of our rules to ensure that we're satisfied ourselves that in justice this person has received the notice and an opportunity to attend, and going beyond the rules. But I do agree with the city clerk that we're best to deal with that situation as if and when it arises, and we can ask our legal counsel for specific ruling on that at that time. But my own feeling is, as a practical matter, who's going to object to the committee doing this? Certainly not a court. A court's not going to say, "Oh, you went too far," and you told somebody who had an interest in the proceeding, gave them another opportunity to be heard.
Thank you. Any further point on that? I have one last point. By the way, these questions occurred to me because I'd rather face them now than face them only at the situation where we have, and we do have a certain amount of time. The next question, or point really, is section 11, sub 4, where if the chair and the vice chair are not there, one of the other members is appointed as presiding officer for the duration of the meeting or until the arrival of the chair or vice chair. But my understanding is that you cannot participate in a deliberation if you've not participated at the beginning. So how could you chair the meeting as chair or vice chair at that point? That seemed to be contradictory to some other part that I read about you must be here for the whole duration as a member.
Chair, there are routine matters of business that you can in fact dispense with that don't involve the actual hearing portions or where this goes in terms of that can be dispensed with if, say, there's a snowstorm or a massive rainstorm or a truck fire on the 417 that impedes you getting in, and it may well be that that's the case. The other piece of that is you may move beyond actual when you're hearing evidence and receiving delegations to the point of deliberations or appointing an auditor or going forward, at which point we would again consult with your legal counsel and see if this was an issue of procedural fairness or if this was simply a routine transaction, such as the matter of selecting an auditor, for example, which is I am not a lawyer, would seem to me to be separate from sitting and hearing evidence on a matter. So really this allows for routine business to be taken care of, that it does not involve a hearing. You can confirm your minutes, you can do several other things.
So in terms of the decision-making process concerning an actual applicant, the person who had been absent up to that point cannot participate in those deliberations.
Correct.
Okay. So that's a matter to be concerned with, should there be lateness on the part of both the chair and the vice chair. Okay.
But if I can clarify, Chair, what this can simply do is you can have a committee meeting, select a presiding officer, and recess the meeting or establish a new time to be 1 p.m. It can be very simple in this regard, and say an appropriate notice be given. It actually allows for more procedural fairness and certainty in terms of who's there. If we hear that someone's unable to attend, it is unexpected, and you can establish a date for which everyone can come forward. That's an administrative matter, and that certainly the committee could do.
Very good. Thank you. Are there any other points concerning the rules of procedure? Douglas.
I hate to do this to the city clerk, but to the city clerk, through you, Mr. Chair, I notice that the rules as drafted do not deal with the lovely question of reconsideration. I say that because reconsideration has always, or used to always be, a bugbear. Would the, in the absence of a provision dealing with that question, would the council procedure, city's procedure bylaw provisions take effect and govern questions of reconsideration? I'm envisioning a case where we've made a decision, and then for whatever reason, either later in that meeting, probably later in that meeting, somebody says, well, wait, I didn't mean to vote for it, or with the majority, there's something else I wanted to consider. And is there any way of it being reconsidered?
If I may, the city clerk's asked me to take a first stab at this. I'm not going to speak to the issue of whether or not the city's procedural bylaw would apply in the circumstances. However, because the committee is created under the specific auspices of the Act itself, its jurisdiction is under the Act. The Act provides that once you have made a decision, the remedy for the aggrieved party is an appeal or a judicial review, as the case may be. There is no inherent power to reconsider at this committee.
Thank you for a nice, clear, succinct answer.
From a lawyer who's trying to be practical, too.
Well, I'm glad you raised that point as well. I think
and just from your rules of procedure, if you go to Section 4, if these procedures do not provide for a matter of procedure that arises during a meeting, the practice shall be determined by the committee chair, and the chair may do whatever is necessary and permitted by law to enable him or her to effectively and completely deal with the matter before the committee. So it gives you some flexibility, and again, within the context of the reason that you're here.
Okay, we're back to seeking legal counsel when and if the matter arises, I think. We'll hope that it doesn't.
Right. I guess we'll just have to pay very close attention as members and avoid the situation. Any other further question or point concerning the rules of procedure? If there are none, I'll entertain a motion, because we have to adopt this through motion. I think Lloyd. Okay, moved by the vice chair. The question is put. People in favor of adopting the rules of procedure? Unanimously approved. Very interesting discussion. Thank you. The next item on the agenda deals with in-camera items. Does anyone have any in-camera item that they wish to propose? There's one member of the media here, so we have to be very careful. No items for in-camera. Okay. Inquiries. This is on the agenda. Are there inquiries by members of the committee to other members of the committee, or to legal counsel, or to the city clerk? No inquiries. Any other business that people wish to raise? If there are none, then I think it is within my power to adjourn the meeting. Am I right in that respect? Having made sure that everyone had their chance to raise any item under any of the preceding 3 items. Then I declare this meeting to be adjourned. The next meeting is to be determined in accordance with the procedures that have been laid out, which is to say we await word should and when a complaint is filed. Thank you all very much. Oh, by the way, we did not deal with one matter, and I should have raised it. Maybe it's too late to do it. And it was discussed at the last time how we relate to the media. Relate to the media. Oh. And do we need to be in session for this? Do we need to be formally in session, or could we just have a chat now? Chat now? All right. So what are the members' views? Because the media may be interested in something that we do at some stage. Who knows?
I don't think we need a formal, nothing in the rules, or we need a formal decision on that, and it may vary with each matter as we go along.
So you want to deal with it from one matter to another? Are we agreeing that one person should be spokesperson for one matter, or?
In default of any specific case where it varies, I would suggest that the chair be our normal spokesperson and deal with the media.
All right. All right. We will accept that as a procedure, and if there's anyone else who thinks that they wish to speak to the media, please just alert us, because it is a right that we all have. Okay? Or we may wish for a particular case to change the spokesperson. Okay? Very good. Thank you.